Pranjal,
Yes, sir.
how are you? Not to be seen?
Good evening, sir. Yes, sir. College some
Where were
clinical
you?
papers are going on, sir. Negotiation. There are some practical subjects. So,
Mm. When is your exams?
sir, exams are from September 21st.
Okay, September 21st.
Yes, sir.
Oh, yes. You are in which semester?
Sir, now ninth semester, sir.
Okay. Mamta, madam? Mamta ji,
Yes, sir.
how are you?
I'm fine. How are you, sir?
I'm very fine. So,
Yes.
last class you attended? Have you?
Yes, sir. I am.
Okay. Aishwarya?
Good evening, sir.
Good evening, Aishwarya. Have you attended last class?
Sir, last class I did not attend the class, sir.
Okay. Yeah, so we will start. It's 7:08, huh? Not to waste our time. See, last class I have started the topic called gift. Section 122 defines about gift. Gift, I'll just recollect. What I taught last class, I'll just summarize it. Gift is the transfer of property from one person to another person out of natural love, affection, cordiality, brotherhood, humanity, etc. So, it is a voluntary transaction where the person, without any expectation, he just passes off the ownership to the other person. So there are parties, and the one who is transferring the gift is called the donor, and the one who is accepting the gift is called the donee. And then there must be the property. The property may be movable property or immovable property. But the property must be present today at the date of transfer, and it should not be a futuristic property. So only the property is in present, is in existence. Only such properties can be the subject matter of a gift. And there has to be the consideration, that is natural love and affection. And acceptance of the gift. Gift has to be accepted. And when it is accepted, according to, there are two schools of Hindu, Dhyabhaga and Mitakshara. And Dhyabhaga says, no, acceptance is not necessary. Even if a person don't accept, it is considered as a valid gift. But Mitakshara says, no, acceptance is a must. Without acceptance, it cannot be a valid gift. So how to create a gift? There are two kinds. One is movable property and immovable property. Movable property, you can just deliver that property to the donee. The donor can simply deliver the property to the donee, and it will be a valid transfer. But in respect of immovable property, general knowledge, you have to remember, when you are transferring a property of value of more than rupees 100, it must be registered according to the Indian Registration Act 1908. Whether you are transferring to another human being, whether you are transferring to another company or another partnership or another firm or another organization, or to a temple, or to a church, or to a mosque, whatever it may be, it must be registered. Otherwise, it is not valid under the Indian Registration Act 1908, Section 17. Okay, so last class I have explained Section 126, very important section. When gift may be suspended or revoked. You know, once we give anything to others, anything, any property to another person, there ends the matter. The property has gone to the donee, and the property will not be the property of the donor. So, once the gift is made, the gift shall be the absolute property of the donee, and it shall not be taken back either permanently or temporarily. If you say that I want to take back my gift, that is very, very bad. It's not dignified. So, Section 126 says, no gift can be taken back under two circumstances. Number one, on the happening of a contingent event. You know, if both the donor and donee agree for the revocation, for the withdrawal of the gift, and they agree for a condition which is not in the control of both the persons, it is beyond their control, then if such a condition takes place, then the gift can be taken back. The gift will be withdrawn. The gift will be revoked. I gave you the example in my last class. In India, before 1947, there were peaceful politicians and there were violent freedom fighters. And I gave that illustration where one violent freedom fighter who is a zamindar, you know, he was fighting, he was caught, he was arrested, he was tried, and he was given life imprisonment in the Andaman Nicobar Island. There he will definitely has to die. And at the time before the departure, he created a gift deed in the name of his brother, saying, my dear brother, today I'm transferring this gift to you. But by chance, if I am released by the government, if I am excused by the government, if I comes back alive to my town, and if you still have the property with you, please, I must take back my property. Kindly give me back my property. So, such conditions are valid. They can take the gift back. They can take the property back. Okay? So here, the release from the jail, the excuse is not in the hand of either donor or a donee. So it is in the hand of the authority. It is in the hand of the government. Only if they excuse, he will come back. Otherwise, no. Okay? So if such a thing happens, gift can be taken back. Second circumstance, when the free consent is not there in the gift. You have studied in your contract, free consent. There should not be coercion. There should not be compulsion. There should not be undue influence. There should not be fraud. There should not be misrepresentation. So, if the donee proves the absence of free consent, and the court will order the cancellation of that document, and the property will come back to the donor. Okay, there I have given you the case Manu Singh versus Somadat Pandey, 1890. A man 65 years of age was influenced unduly by a Swamiji, and all his property was secured to him, his name by means of a gift deed. And this was challenged subsequently. And the court accepted that there was no free consent. Swamijis can destroy the mind of others, the devotees, the disciples, especially the rich class of people. They will hunt down and they will snatch away the properties of rich class people. So the court found Swamiji has played undue influence on the mind of the devotee, and they cancelled and ordered the return of the gift. So again, this much I have taught last class. And today I'll continue. Section 127, onerous gift, and Section 128, universal donee. Make it important, okay? They may ask you for a short notes. Either they will ask you for that is universal donee, or they may ask you onerous gift. Kindly write both. Okay? Together you remember section 127 and 128. You simply write both.
So if any of the one will come, we have to write both.
No, they will ask only one. Okay? They will ask only one. They don't ask both. Okay? So when they ask it one, kindly write. When they ask only this universal donee, write 127 plus 128 so that it will fetch us you more marks. Okay. Now, onerous gift. You see, we are all lucky to have a father who has earned lot of property, who has earned lot of money, who do not have any loans, and we will be happy that our life will be very peaceful. अरे यार मेरा पिता का तो इतना property है, वो इधर है उधर है. So many things. They are lucky sons and daughters. But there are certain fathers. He may be having small properties, and he is having loans on the property. Loans and loans and loans. If such a person is having properties with loan, and if such a person creates a gift of his property to his son or daughter, and such properties with loans, liabilities, burdens, charges, they are called onerous gift. Means gift which is very heavy, gift with liabilities, gift which are burdensome. Okay? So, let us take simple example. Carefully apply your mind. Consider Mr. A is having 2 houses. Mr. A is having 2 houses. House number 1 and house number 2. On house number 1, he is having a loan of some lakhs. On house number 1, he is having loans. On house number 2, he do not have any loans. Consider Mr. A prepared a gift deed in favor of his son. And in the gift deed, he mentions, I am the owner of 2 houses, and I am on the house number 1, I am having a loan of this many lakhs of rupees. So, I am transferring both the houses as a gift to my only daughter. Now the question is, whether this is a free gift, whether this is an attractive gift, whether this is a gift with burden, a gift with liability, a gift with loans. So, if both the properties are executed in a single gift deed, the donee has to accept completely, fully. He cannot reject the burdensome. He cannot accept the zero burdensome properties. When a gift is with liabilities along with other property without liabilities, if it is executed in a single gift deed, the donee has to accept completely or he has to reject completely. Such properties with liabilities are called onerous gift. Section 127. Okay, common sense, you tell me, you give me the answer now. Consider the daughter has accepted both the gifts. Now, is she liable to clear the loans of her father or not? Come on, answer.
Yes, sir.
How much loan that she is liable? Is it all the loans made by that man in his life? Or is it only those loans which are on that property?
Sir, I think the leftover loans, because when such property is gifted, in that case, I think one or the beneficiary or the donee can accept the part, like beneficial part of the gift, and they can reject the onerous part of the gift. So they can't, like, if they don't want, they can, like, a particular condition should be mentioned, I think.
Yeah, any others? Do you want to give mukti to your parents or not? If, we have, all of us have to pass away. We all die. But when such parent has given the gift to the daughter and there is liability, what is the moral duty of that daughter? To clear the gift, to clear the loan, or not to clear the loan?
To clear the loan, sir.
Yes. Now you read, one of you read section 128.
Subject to the provision of section 127, where a gift consists of donor's whole property, the donee is personally liable for all the debt due and liabilities of the donor at the time of the gift to the extent of the property comprised therein.
Therein, what is the meaning of it?
So I think if a donee is taking the whole, like if the donor is giving the whole property to the donee as a gift, so donee will be liable for everything which is all the onerous condition which is attached to the property, which will also include debts and other liabilities.
Yes, very good. So So we must be very careful here, especially the sons and daughters. When they are accepting the property from their parents, they must be very clear. The parents are having properties with liabilities and without liabilities. And if the parents are transferring the property as a gift to the sons or daughters, and it's all the property is in a single gift deed, then the daughters, that is the donee, has to accept it fully or to reject it fully. Now, when they have accepted it fully, it is the duty of the donee to take up the responsibility to clear all the loans of that donor. Until the time of making the gift, whatever the loans were there on the property, and all such loans has to be cleared by the donee. So, the donee is answerable or liable to clear the loans of the donor which is in existence on the property. Then such a donee who is having the duty to clear the loan of the donor is called as universal donee. That means he is answerable. He is answerable to clear the loans on that property. Right? So it is not tough. If they ask you a short notes, universal donee, kindly write section 127 and 128 together. Only then your answer will be valid and correct. Okay, so this much is enough about the transaction of gift chapter. Okay, now I'll take you to another small short notes in the transfer of property. That is the last topic, transfer of actionable claims.
129 is not important.
No, ma, not important. Okay, only those which touches you for your exam, I'm just explaining. Okay, I'll take one small example so that you can easily understand the word actionable claim. In the life of a girl, this incident may take place. What is that?
Marriage.
No, अरे शादी तो बाद में यार, अभी बहुत वक्त है. Consider you are having a wonderful jewel with you. One beautiful jewel. You have a girlfriend. You are a girl and you have a girlfriend. And that girlfriend one day saw the jewel in your ear or in your hand, and she says, "What a wonderful jewel." She was very close with you. One day she came and asked you, "Will you please give me this jewel for a week? I want to wear it in a marriage, and after that, I will deliver you back." So she was liking you, she was loving you, she was speaking to you, she was understanding you, everything, she was good. Now, you have just gave that jewel to your friend. Now the question again. That person took the jewel. She attended the marriage. And in the marriage, she just simply was wearing the jewel. And everyone looking at her, "Ah, what a wonderful thing." And afterwards, she never visited you. She never called you. She never said anything about the jewel. She is simply not in touch with you. What are you going to do? Come on, tell me.
We can sue them.
Little louder.
So we can sue.
Okay, very good. Do you have any right on the jewel or not?
Yes, sir.
Why?
Because I was the transferer who gave that jewel to my friend. So
Uh-huh.
there is not any kind of gift or charity which I did. So the transferee has right to, like, I have the right to recover
Hmm.
that property which
Hmm.
belongs.
Okay. Any others? How you are going to recover? Aishwarya ji, are you going to give up like that?
No, sir, we'll ask her back to return the jewelry.
How you are going to ask?
Sir,
How?
probably through actionable claim only, because that is a topic which will come.
Now if you are the owner of the jewel, you will be having some proof, is it not?
Yes, sir.
Okay. How you got the jewel, who gave you, when you purchased it, so many details you will be knowing. Maybe your father has given the jewel, or mother has given the jewel, or someone has given the jewel. So, you are the lawful person. You are the lawful owner of the jewel. You have the right to use, you have the right to possess that jewel. Since you are the absolute owner of the jewel, you may temporarily lend it to other person for a temporary use, and that person has the duty to use and to return that jewel. You as the owner has the right, and that right to take back the jewel is called actionable claims. Very simple. What is actionable claim? You are the owner of a jewel. You have just temporarily given it to others, and now that person has not given you back. You have the right to take it back. That right is called as actionable claims. Okay, some more examples which are there in our day-to-day life, in our ordinary life every day. See, there are people who always live on the money of others. Always. Whether it's a boy or a girl, whether it's a man or a woman. Some of them, not all, there are good, respectable human beings in our society. But there are people who always, want to suck the money of others. You may find them in your student life. You may find them in your relatives. You may find them as your neighbors. Consider one person, a friend, let us take a friend. He says, I am in need of 2 lakhs of rupees. I need it for about 1 month. Give me now. I will give you back. Some money will not come back. It will just vanish like that only. You, the hard earner of money by your sweat and blood, you have collected the money. You are keeping the money for your bad days. And your friend or a relative has asked the money, a loan, a hand loan for a period of 2 months, 3 months, or 6 months. You have given the money, and now The friend who has taken the money fails to return. You, as the owner of that money, you have the right to climb back. You have the right to take back that money. Such a right is called actionable claims. Okay? Another illustration. See, I'm giving you these illustrations taken from the ordinary life of all of us. So you can write, if they ask you a short notes in the examination, all these things. It's very, very simple topic. I think all of you are in the habit of drinking in the early morning a cup of coffee or a cup of tea or a cup of milk. Some of you may be. Some of the people may not even have that opportunity to consume a cup of milk or a coffee or tea. So let us consider there is a milkman. He is supplying the milk every day to a particular house. So the milkman supplied the milk for 1 full month. And money, the cost of that milk. After 1 month, the house owner who received that milk has the duty to give back that money. Calculate how many days of missing of milk, what is the price of milk per liter, calculate, and the amount of money has to be delivered to the milkman or the milk supplier. When the consumer fails to pay the money for the milk supplied, and the milkman is having the right to get that amount of money. So, that right to take back the price for the milk supplied is called as actionable claims. Right? One more illustration. See, there are good people even today, here and there, in our society. Let us take one good human being who is a cement dealer. He is selling the cement. And we'll call him as Mr. A. He was so good, his face was good, soft-spoken, soft-hearted person. And one Mr. B took some 100 bags of cement and promised, tomorrow morning I will get you the money. Okay, so now I need 100 bags. Immediately the work has started. So A, the cement dealer, has supplied the cement. And the one who received the cement, Mr. B, failed to keep up his promise. And the cement supplier has the right to collect all the money for the cement supplied. So, this right is called actionable claims. Hope you understood this point. Actionable claim. Okay? Any doubt in this? No doubt? Pranjal, have you understood?
Yes, sir.
Okay. So, there is another word for this actionable claim. There is another word. They may give you in the exam. They want to confuse the student. So, chose in action. CHOSE, chose in action. See that word, if they ask you in the exam, write short notes, chose in action. Write this topic only. Okay? So whatever services that we have rendered, whatever properties we have given, whatever good things that we have done, whatever money we have given to others, whatever movable properties we have given to others lawfully, we have the right to take it back. And such a right is called as chose in action or actionable claim. Now the topic name is transfer of actionable claim. What is this? Whatever claim that we have, can we pass this claim? Can we transfer this right to any of our friends or relatives or servants or agents or family members? The law says, section 130 says, yes. If a person is having the actionable claim, he has the right to transfer the actionable claim to other persons. Maybe a friend, maybe a relative, maybe a good person, etc., etc., etc. Then how to transfer it? Very simple. See, first example I told you about the girl, a jewel. And the girl has given the jewel to another girl for a temporary use, and another girl has not returned it. And the first girl, who is the owner of the jewel, she is having a very big muscle-powered brother. And she says, she has prepared a white paper from to subject, transfer of my right or actionable claim. There she can write, I am hereby transferring my right to claim back the jewel from you. I am transferring this right to my brother, who is a very good muscle man. He is coming to your home and you must deliver this jewel to him. Otherwise, we are going to take lawful action against you. Very simple writing. So that brother with the letter can go to that house of that girl number 2 who has received the jewel, meet her, show the letter to her, and climb back that jewel. So whoever is having any claims, they can transfer it on a white paper signed by the first party. Okay? And that will be a valid transfer. So this is a very small topic for your short notes. And see, this topic is having so many sections, 130 to 137, not important. Only 130 is important, plus section 3, the definition of the word actionable claim. Okay, it is an unsecured debt, means the hand loan or the properties movable given to the other person. Okay, and it does not include the mortgages or the pledges of jewels, pledging, to take loan, they pledge. No, those things will not be discussed here. It's only the simple giving of hand loan, giving of our property to others for temporary use and lawfully, and we have the right to take back our jewels, our property, our money, which we have given already to others. So this is actionable claim. Okay, so 130, only one section is important, and all these are not at all important. Okay, so this much is enough for our transfer of property act. I will make some corrections to this piece of notes. I will send it to you tomorrow. Okay, so you please ask any questions if you have any doubt in this. If not, I will commence Criminal Procedure Code 1973. One by one, can I commence Criminal Procedure Code?
Can we discuss some important, like once again, can you tell, like, very, very important questions, or like, which usually asked in MCQ exams, PT exams?
So take, if you have a paper with you, simply make some points. Section 3.
Oh, just 1 minute.
All of you, just open the one page, hold the pen and start writing. Section 3.
So this is for you are giving, like, telling for both and main exam and
Yes, yes. Section 5. Section 6. Section 10, 11, 12. Below you take down Section 5 plus Section 13 plus Section 14 plus Section 18.
together all.
Together, all the sections must be included.
So please repeat once.
Section 5, Section 13, Section 14. Okay, Section 18. Or they may ask you Section 17 plus Section 18. Another Section 19 and 20. And 21.
So these all which you are telling together, these two can come.
Means one question you will get. Next, Section 25, separate question. Section 25 plus Section 26 plus 29 then you go to Section 35 separately, you'll get a main question. 36 and 37 together, one question. "38" separate question. Then Section 41 separate question.
40 not, sir.
Now 41, "51, 52, 53, 53A. 4 different questions important.
Please repeat.
51 separate question, 52 separate question, 53 separate question, 53A. 54 to 57, sale. Next, section 58. Separate question you will get. Section 60. Separate question. '63. Separate question. 65. Separate question. 65A. Separate question. 66. Separate question. 67. Separate question. 68. Separate question. 69. Separate question. 70. Separate question. 72. Separate question. 73. Separate question. 76. Separate question. 48 plus section 78.
48 plus 78, sir.
Section 48 plus section 78. Section 81 plus 82. Separate question. Section 83, separate question. Section 83 plus section 84. Section 83 plus section 84, separate question. Section 91 plus 92 plus 93 plus 94. Section 100. Separate question. Section 102 plus 103. Section 105 plus 108. 105 plus 108.
Is 6 not important?
Yes, ma'am.
106 not important, sir.
Not important, so important. You know, they will ask you define lease. Okay, there you have to explain lease. And then, you know, you have to go to this rights and liabilities of the lessor and the lessee. They may ask you lessor or the lessee, right? So combine, you know, you have to connect different sections together. Then you have to go to section 111. Allow all other sections, don't worry. Or section 111, important, separate question. Then this forfeiture section 111 G, section 111 G forfeiture plus section 112 plus 113. Okay, if they ask you for forfeiture, then yeah, you can go to section 116 short notes, tenancy at will and tenancy at sufferance. Then exchange 118 to 121. One small short notes you will get. 1 page or 1.5 page you have to write. 118 to 121. And then the gift is very, very important. In whatever exams you take, they will ask this topic.
From 122 to 129.
Yes, 122 to 129. So explain section 122 plus 123 plus 124, 125. Sometimes they will ask you 122 plus 126. Definition of gift, when the gift may be suspended or revoked. So, okay, 122 plus 126. Or another question, 127 plus 128. Then the last topic which I have done today. So, short notes, section 3 plus section 130. Section 3 plus section 130. Okay? So, whether you take up any kind of exams, you try to do this, read this, and
It's 8
Well-
o'clock.
and you can easily pass this one. Okay, so all of you have a pen and pencil with you.
Sir,
Hello.
hello.
Yes,
Amma.
sir.
Sir,
Okay.
if you don't mind, can you just want to repeat after 108? Like after 108, what I said, I just missed that. My network got disconnected.
108.
105 plus 108 done, sir. After that, what you said?
Yeah. What is 105? Leases. Okay. Then you go to section 112. Determination of lease.
Okay, like from 8 directly, it's 1
Yeah. 105 plus 112. Okay.
Yes, sir.
Yeah. Okay. So that much is enough about Transfer of Property Act. It's the smallest subject, and it's purely civil. Okay. Now, the bulkiest subject is the Criminal Procedure Code 1973.
Sir, excuse me, like,
Yes, ma.
it's an introduction or it's already begun?
No, ma. Today I have to start.
Oh, okay, sir.
Okay.
Okay, sir.
Yes. Now, all the people generally, whether they are good, decent, dignified, whatever you may, I think you have interest. You don't have that much interest in civil subjects, but you will be having more interest in criminal subject. Is it not? All of us?
Yes, sir.
Right?
Yes, sir.
Now I want to know from you, have you ever learned, understood the Indian Penal Code? If so, tell me, what is Indian Penal Code? All of you, one by one. What is Indian Penal Code?
So, it is like criminal code of procedure in India. So it basically deals with all the criminal matters,
Mm, mm.
and it came into existence in the year 1860.
Okay, ma'am. Okay, okay. Yeah, others. Good, Mangala. Others.
100 culprits escape from the punishment, but one innocent cannot punish under the IPC.
Okay. So one innocent should not be punished.
Under the
Okay.
IPC.
So many criminals can be allowed to go. Right? Good. Yeah. And Lavin, what is IPC?
Sir, basically, it is a codified law which has all the penal sections like punishments and fines for every different form of criminal offenses.
Oh, yes. Okay.
So,
Good.
as per the Indian laws and Indian situations.
Good, good, good. Pranjal,
Yes, sir.
what is Indian Penal Code?
Sir, it's an criminal code of India,
Hmm.
and sir, it's mainly for punishment of some criminal offences committed in India, sir.
Okay. Okay. See, all of you. Speak with the knowledge of law. You know, you can classify yourself as a person with little knowledge of law and other persons who do not have knowledge of law. If anyone asks you, what is the meaning of Indian Penal Code? Remember, only one sentence your answer. Indian Penal Code is a statute on the topic of crime and punishment. That's all. Indian Penal Code is a statute on crime and punishment. IPC is a law. On what topic? On what subject? On the subject of crimes in India. And what kind of punishment has to be given for the crimes? So Indian Penal Code contains two things. One is crime and another is punishment. Indian Penal Code is having 511 sections. So it is a very bulky explanation about crimes and punishments. There are so many theories of crimes and also the theories on punishment. So in our society, we are the human beings. We commit crimes. Knowingly, unknowingly, purposefully, voluntarily, with good mind, with bad mind, we commit crimes. When there is a crime, there has to be a punishment. And what will be the punishment? What are the crimes? Fraud, acts against the government, destruction of public property, destruction of public peace, crimes against the life of a human being, crimes against the property, crimes against our body, so on and so forth. So broadly we have murder, rape, theft, defamation, extortion, kidnapping, hurt. So IPC is about crime and punishment. We know the essentials of crime. There has to be a human being, there has to be a mens rea, there has to be a physical act, there has to be a loss, damage, destruction, death, all this combined together to call an act as a crime. So, if there is a crime and a punishment, maybe a death sentence, maybe a life imprisonment, maybe a rigorous imprisonment, maybe a simple imprisonment, maybe a form of penalty, maybe confiscation of property. So many things. So, when a crime takes place, what is the next method, next step? The crime has taken place. Now, how to provide remedy? How to punish? And the answer is Criminal Procedure Code 1973. So IPC explains about crimes and punishment. CRPC explains about the procedure after the happening of the crime, how the police department has to proceed, how the criminal law court has to proceed, how the public prosecutor how to present, how the defense advocate how to present, how the judge has to conduct the trial, how the lawyers have to argue, how the judge has to write the judgment. So CRPC is nothing but the procedure to be adopted by the police department after the commission of the crime, and the procedure to be adopted by the criminal law courts of our country. So what is CRPC now? CRPC is the procedure to be adopted by the police and by the criminal law court. That's all. Okay? So you know the difference between IPC and CRPC. Come on, one of you tell me what is IPC and what is CRPC? Any one of you? ममता जी, आप बोलेंगे?
Yes, sir.
What is IPC? What is CRPC? Tell me.
IPC is the statute of a crime and punishment.
Very good. Then,
And CRPC is the procedure which is adopted by the police or the criminal court.
criminal court. Okay? Yes. So, if anyone asks one sentence of answer, IPC is the statute on crime and punishment. CRPC is the statute on the procedure to be adopted by the police and by the criminal law courts. There ends the matter. See, just about 2-3 days back, you have celebrated, what is that, Indian Independence Day. We celebrated that we are free from British, but we are not free from ourselves. We are not free people. We cannot. We are dividing India once again in the name of language, religion, race, caste, place of birth. So many things as we are destroying India. Once again, our politicians are going to destroy this country. But I always look at the British, how knowingly or unknowingly they united India. Indians were like amoebas, dividing themselves on the basis of language, religion, race, caste, sex, place of birth, color. But British people united India by giving a unified law. I think they didn't know what they are doing at that time. Otherwise, they would not have been created these uniform laws applicable to the whole of the country. They have contributed wonderful buildings to our country. If you come and see the High Court building of Bangalore City, it was built in 1860. Now it is 2020. It is standing majestically to show the sincerity, at least in the construction of buildings for India. See this criminal procedure code. The name is 1973. So it speaks about police and the criminal law code, and it says 1973. General knowledge. We have to gain knowledge. Before independence, before 1947, some people say there was no India at all. Only now India came into existence. Fools and stupids. Hindustan pehle bhi tha, aage bhi rahega Hindustan. India was in existence some thousands of years. It will be in existence for the next thousands of years. Whether A will be leading India or B will be leading India, these people will come and go, but India will remain. Before 1947, the British government saw the condition of this country. Linguistic divisions, divisions of north and south, divisions of color, hatredness. So, the British government, they were very good in administration, have constituted 4 law commissions. 4 law commissions in India. The first was in 1833 under the chairmanship of Lord Babington Macaulay. He is the father of Indian Penal Code. So, afterwards, the second law commission came into existence, and all the 4 commissions was given the duty to create a criminal procedure. At that time, there were 2 kinds of towns and cities. One was called presidency towns. That means what today you are seeing, Madras, Bombay, Calcutta. In those days, they were called presidency towns. And all other towns with low population were called as provinces. So in these presidency towns, they had established a superior court It was called as Supreme Court, not the present Supreme Court. Don't get confused. Don't get confused. In those days, in the presidency towns, okay, there were superior courts called the Supreme Court. So these commissions created, drafted the criminal procedure Supreme Court Code 1852. In the year 1852, they created criminal procedure code applicable only to the Supreme Court, that is of Calcutta, Madras, and Bombay. But as the time passed, what about the ordinary towns? They wanted to solve the crimes in these ordinary towns. So they drafted another law called as Criminal Procedure Code 1861. Very simple thing, okay? So what you have to be in your mind, before the freedom of our country, there were 4 law commissions. And these law commissions, they have drafted a separate Criminal Procedure Code 1852 applicable to the presidency town, and subsequently in 1861 Criminal Procedure Code applicable to the provinces. And the time passed. The Law Commission thought that why should we have 2 different criminal procedure code? We must have one criminal procedure code. So, in the year 1882, a uniform criminal procedure code was drafted. It came into force. And this 1882 received amendments in the year 1898. So, for the entire nation, a uniform criminal procedure code 1898 was applicable to the entire nation, to all the cities, all the town, all the villages. See, when you make a law, it must be strong enough to withstand for many, many years. Law is for the nation. So 1898, when they made the law, it continued even after 1947. After 1947, Constitution came into existence on 26th January 1950. And the government of India thought that we Indians are very great. We have brainy people. We have to make changes to the CRPC. So in 1955, the Free India appointed the Indian Law Commissions. And they were given the duty, come on, you must make a beautiful law. And the Indian authorities, Indian jurists, applied their brain, made changes to the present India. And in the year 1973, they completed the changes and submitted to the Parliament and the President. In January 25th, 1974, the President gave his consent, and it came into force on 1st of April 1974. So the Criminal Procedure Code 1973 came into existence on April 1st, 1974. Underline this word, it will be for your examination.
Sir, so in case if they will ask the year for criminal procedures, so we will not write 1882.
Then no, don't write 1882. Okay, because now it is the Criminal Procedure Code 1973 only you have to write. Okay?
Okay, sir.
Yes. So let us understand CRPC, wonderful subject. This CRPC 1973 contains 484 sections. 484 sections. And all these sections have been arranged into 37 chapters. So there are 37 chapters, 484 sections, and there are 2 schedules, means lists. So if anyone asks you how many sections are there in CRPC, how many chapters are there in CRPC, you have to say by heart 37 chapters, 2 schedules and 484 sections. What is CRPC? CRPC is about the procedure to be followed by the police department and by the criminal law courts. Okay? So, let us understand a very bulky topic. I need 6 months to explain this. But for your examination, simply take down those things as which are very, very important for you. See, what is CRPC? How many chapters are there? 37 chapters are there. And 2 schedules are there. 484 sections are there. Now, what is this 2 schedules? Now, for our simple analysis, you see list. List number 1 or list number 2. So like that, schedule number 1 and schedule number 2. In this first schedule, it has classified Indian Penal Code. It has classified Indian Penal Code into bailable offense, non-bailable offense, cognizable offense, non-cognizable offense, warrant cases, summons cases. Okay? So, first schedule or schedule number 1, what it contains? It has classified Indian Penal Code into bailable offense, non-bailable offense, cognizable offense, non-cognizable offense, warrant cases, summons cases. Right? So first schedule or schedule number 1. Now what is the second schedule? Second schedule contains documents. For example, the summons, the warrant of arrest, the attachment. Like this, it contains number of different judicial documents. So, important for you, chapter number 1, it is called preliminary. Chapter number 1, preliminary, it commences section 1 to section 5. So don't simply listen. If possible, kindly make points on the white paper. So chapter 1 we will commence. Under this chapter, there are 5 sections. section 1 to section 5. Under this, important for your examination is definitions section 2. Definitions section 2. Okay? Now, they will ask you in the examination the word bailable offense. They may ask you for short notes. Bailable offense, or what is bailable offense? What are bailable offenses? They may ask you. The definition is section 2A, bailable offense. Section 2A explains both the words bailable offense and non-bailable offense. Section 2 explains bailable offense and non-bailable offense. What is this word, bailable offense? I told you, first schedule. It has classified all the crimes of IPC into bailable offense, non-bailable offense, cognizable offense, and non-cognizable offenses. So every one of you must have the bare act of Criminal Procedure Code 1973. So section 2A, you have to write in your words, those offenses which have been described as bailable in the first schedule are called bailable offenses. What is the further meaning of this? When a person is arrested, kept in the custody, and the trial will take many months and years, he wants to come out of that custody, detention. And if the offense is explained in the first schedule as bailable offense, yes, definitely he will be released from the custody until the completion of the judgment. So, generally bailable offense means ordinary offenses, not so serious offenses. Now you have to classify out of 511 sections, you have to classify which are bailable offenses. Now here I will be giving some 4 or 5 offenses only, okay? So that you can easily remember. For example for bailable offenses. You know, section 141, unlawful assembly. A group of 5 members or more than 5 members comes together with an object to create fear in the mind of the government, to trespass, to dispossess the property of others, or to destroy the public peace, or to compel the governmental authorities to do an unwanted act. So, if any group of 5 or more than 5 comes together, we call them as unlawful assembly. And you know, if a group of unlawful assembly and all the members have assembled unlawfully, and Section 143 says, yes, they must be punished for a maximum of 6 months of imprisonment or fine or both. So, any member of unlawful assembly is coming under the bailable offences. If he is arrested, he can be released on bail. Okay, so simply make points in your. I have not prepared the notes. Now I am preparing the notes. I think I take a lot of time to prepare. So kindly make some points in your white paper. So, example for bailable offense. Section 141, unlawful assembly, and 143, punishment for unlawful assembly members, is a bailable offense. 6 months or fine or both.
Sir, can you please repeat once again, please? Example.
Section 141, unlawful assembly, plus section 143, punishment for the members of unlawful assembly, 6 months or fine or both.
Yes, sir.
Next one, section 172 of IPC. See, all this I'm IPC only, okay? Section 172, absconding to avoid service of summons. Summons is an invitation or an authoritative invitation by the court to any person to present themselves before the court on the specified date and time. It is the duty of every Indian to accept the summons. If any person against whom the summons is released purposefully, voluntarily, knowingly hides himself or absconds himself or undergoes, and he goes underground, it will be an offense under section 172. And the punishment will be imprisonment up to 1 month or fine of 500 rupees or both. Or, yeah, if that compulsion to present before any, non-judicial authorities, then the punishment is 1 month or 500 rupees or both. But if the court has given the summons and it has to be accepted, and if anyone avoids it, absconds, then it is 6 months or fine of 1,000 rupees or both. So this is also a bailable offenses. Hope you are finding out. I'm speaking about what kind of crimes are there. It's not a very hard crimes. It is a simple crimes. Now, section 193, another punishment for false evidence. Sometimes I believe nowadays, Shanti Bhushan, one of the senior advocate, I don't know about today's this one, what I heard about 3-4 days back. The Supreme Court judges have become the slaves of the politicians, and they are holding him liable for contempt of court, and he may be put behind the bars. When he questions, when the retired judge accepts the benefits from the political parties, when that is questioned, it is called contempt of court. I don't want politics, but still I feel pain for this country. False evidence. Whoever comes to the court of law, they must give real evidence, true evidence. If anyone gives bogus evidence, concocted evidence, it is an offense. And the punishment will be maximum of 3 years and fine. So it's a bailable offense. So anyone coming to the court and giving false evidence, it's a bailable offense, 3 years and fine. Another section 231. I have just collected from different topics. Counterfeiting coins. Coins in our country is having a history. Once upon a time in this golden India, there were golden coins. Today we have some of the currencies of low quality currencies. I asked once, I visited the Reserve Bank of India. I asked the officers there, why the notes which were printed 10, 12 years back, it is even today strong, why the notes printed last year is not of that quality? He says, sorry, we cannot speak. Okay, counterfeiting of coins. Duplication of coins. Creating similar coins in an unlawful manner. A coin, governmental coin, which is in existence, and others will duplicate it. So duplication of governmental coins attracts punishment up to 7 years and fine. So this is also bailable offense. Section 269. This section, I think, relates to the present day world. Section 269, negligent act likely to spread infection of disease dangerous to life. If anyone purposefully spread infections to others, which is going to kill others, which is harmful to the life of human beings, and such a negligent act is an offense, punishment, 6 months, or fine, or both. This is also bailable offense. One more section, section 297, trespassing on burial grounds or burial places. Whatever place may be there for the final rest of the human beings. It may be a tower of peace or tower of silence. It may be a cemetery. It may be a land where they dig and fill the body. So burial places should not be, trespassed. We should respect the place, whether it belongs to one group or another group of human beings. If you don't like, we should not visit the place. But once we visit the place, once we enter, we must behave properly. Entering the burial places, creating mischief, showing disrespect to the process adopted there will be an offense, and the punishment is 1 year or fine or both. Okay, so section 325, grievous hurt. If you cause hurt to others purposefully, voluntarily, and the punishment will be 7 years and fine. These examples are for bailable offenses. So kindly, if they ask you a question about bailable offenses, you have to remember section 2 Yea, and at least you write 5 different such offenses. Got the point? Now we will go to the other offense. Non-bailable offense means serious kinds of offenses, and if it has taken place and the one who has committed the offense has been taken into custody, and the law says, and the first schedule says, the non-bailable offenses means those offenders shall not be released pending the trial. It's only in the books. It's only in the books, okay? Bailable offense, non-bailable offense, it's only in the books. Today, even if you commit 100 murders, you will get the bail. You'll be released. So you have to give some examples for this non-bailable offenses. So, Section 115 IPC, abetment. Abetment of offense punishable with death or imprisonment for life. Punishment is 7 years and fine. Can anyone tell me what is abetment? If you remember.
To instigate or to provoke someone.
Very good. Brainwashing. That's what's happening nowadays. All the TV channels, all the newspapers, they are doing this. Brain. We should not give our brain to others. Otherwise, they will manipulate our brain and they will make us as a slave. You need not accept what all I teach. You need not accept. You have your independent thinking. Whatever I teach, you listen, you analyze. Only if it is proper, you accept. Otherwise, you reject. But there are sons who are mother's sons. Consider there is a mother and a son is married, and mother don't like her daughter-in-law, and she tells her son, "Are yaar puttar, I will get you a beautiful queen for you. Why can't you kill this lady?" Mother and the son says, "Hanji mother, I will do it." "मैं कैसे करूं मदर जी?" "अरे बेटा, कुछ खाने में तो मिक्स करके दे देना." Right? So she will give some potassium cyanide drops, and that innocent son obeys the mother and puts some drops into the food, and the lady, out of love and affection, she consumed the food. Next 20 seconds, she is no more. Mother has made the abetment to the son to kill his wife. So that mother is liable for punishment, and she will be punishable with death sentence or life imprisonment. And such an abetment is a non-bailable offenses. Okay, small section 115. We'll go to next one, 121. Waging of war, attempting to wage war against the government of India. So, in South India, there was a Tamil terrorist organization called LTTE. Those people who killed one of the prime minister ex-Prime Minister of India. Any group, any organization which wages war against the government of India are committing an offense, and they will be punished with death sentence or life imprisonment. So if you wage war against government of India, it's a non-bailable offense. Section 124. There was a wonderful president in our country. Hope you remember. He was always in the news, talking to the children in a gentleman manner where he was visiting good places. He wanted to mix with the students of this country. Today he is no more. But he has invented wonderful missiles for the protection of India. Agni. Do you remember? Who is he?
Mr. Kalam, sir.
Mr. APJ Abdul Kalam, wonderful scientist, sincere man, honest man. And the politicians of this country have suppressed him. They failed to give him the second term because he is sincere and honest and he belonged to one religion. Today, no politician can protect India except the missiles developed by APJ Abdul Kalam. Okay. Now today we are having one more president. I think he don't even show his face. Okay. Wonderful president. So, whomsoever may be the president, we must respect. We should not create fear in the mind of the president or the governor. We should not write dirty letters. We should not make dirty phone calls. And such will be an offense. And the one who commits such assault is 7 years of imprisonment and fine. So 124, it is a non-bailable offense. So 124A, sedition, spreading hatredness against the lawfully established government, is an offense. Punishment, life imprisonment, and fine, or such a act is also a non-bailable offense. One more section, 128. Prisoner of state or prisoner of war. Prisoners will be in the custody of our authorities, any authorities. When any officer is having that authority to keep a prisoner, they must take care. And if any such authority, either carelessly, negligently, purposefully, voluntarily, allows the prisoner to escape, it's an offense. And the punishment is 10 years and fine to that officer or to that servant, governmental servant. And it's a non-bailable offense. Section 153A, useless sections, all these are in today's India. Promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, and doing acts prejudicial to maintenance of harmony. So, hate speech, condemning a particular religious people, always showing them as the criminals, is division of India, and the whole world is watching. Okay? It's also a non-bailable offense. Okay, so all of you buy this one, the Behr Act. And what all I have created here will come under the non-bailable offenses. Okay, so section 2A, bailable offense and non-bailable offense. So in the exam you write at least five simply write 5 sections or 5 offenses. Right? Yeah, we will go to next important section, section 2C. Cognizable offense means an offense of the serious kind in which the police officer is having the power to arrest that offender without any warrant of arrest. The direct power to arrest a person if he commits an offense, and such an offense is called cognizable offense. Right? Cognizable. So give some examples. So you simply, you take down section 121, waging war against government of India. Okay? Section 128, public servant voluntarily allowing the prisoner to escape. Section 150, hiring persons to join unlawful assembly. Section 152, assaulting or obstructing public servant when suppressing right. Section 153A, promoting enmity on the basis of religion, race, place of birth, etc. Offenses committed in a place of worship. 170, personating a public servant. Okay, so these are some of the offenses for cognizable offenses, examples. Yeah, now you tell me the opposite of cognizable offense. Non-cognizable offense. Hope all of you understood cognizable offense. Tell me the opposite of cognizable offense. What is non-cognizable offense? Any one of you?
Sir, without warrant also the arrest can be done by the police officer.
Without a warrant, no one can arrest.
So, cognizable, non-cognizable offenses means some lighter kind of offenses, and the police officer do not have the power to arrest. If he wants to arrest, he must have the warrant. Okay? So a police officer can arrest only with warrant of arrest, and such offenses are called non-cognizable offenses, section 2L. Okay? So first is 2A, bailable and non-bailable. Both are in 2A. Okay? Then you have to explain that that is cognizable offenses, section 2C, and non-cognizable offenses, section 2L. You have to by heart. These sections are important for your examination, so you have to by heart. Okay, now examples for non-cognizable offenses. Section 137 IPC. You know, deserter. All of you know this word, deserter. Who is a deserter? Who is a deserter? You have not heard this word, have you?
No.
You know, who is in the Indian Army? All the sons and daughters of top 5 rich people of this country? Who is in the Indian Army? The people belong to the lower strata of the society. The have-nots, the sons and daughters. Who is protecting our country? There are young boys and girls joining as commandos. Some of them cannot withstand the training. They unlawfully, without informing, they leave their jobs. And such persons who comes out of the Indian Armed Forces without permission are called deserters. So, if any such Indian Armed Force personals illegally comes out and they hide themselves in a ship, and the owner of the master, that is a captain of the ship, must be careful. But if he allows, or without his knowledge, if a desert is hiding in a ship, then the captain is responsible for it and he is committing an offense under section 137. So he will be given a penalty of around 500 rupees. Okay? So this is non-cognizable offense. The police cannot arrest that captain without warrant of arrest. Okay? And the owner, another section 154, the owner of a land on which an unlawful assembly is held. And the owner may be knowing that an assembly is going on or not. And such owner cannot be arrested without a warrant of arrest. 168, public servant unlawfully engaging in trade or business or private occupation, private profit making, etc., is an offense, non-cognizable, 1 year or fine or both. Okay? And another section 169 of IPC. Public persons should not, public servants should not buy the property which is to be put into auction by the authorities. They should not. If they buy, yes, it is also an offense, non-cognizable offenses, and 2 years of imprisonment or fine or both. Section 171E, punishment for bribery. Yeah, we are Indian. Every iota in our blood is sincere and honest. Honesty is there. We don't accept bribe. But one here and there may take bribe. Okay, so there, if you take bribe, it is also non-cognizable offenses, and the punishment is only fine. So, like that, some of the sections you create, right? So, that's enough. So, for 4 topics we have understood: bailable offense, non-bailable offense, cognizable offense, non-cognizable offense. And 2 more points I would like to give you here. Warrant cases. Section 2X, warrant cases, means those criminal cases which attract imprisonment more than 2 years. So those criminal cases which attract imprisonment for more than 2 years is called warrant cases. Section 2X. So there, culpable homicide, life imprisonment, murder, life and death, 304B, dowry death, okay? 307, attempt to murder, 310, thug, 363, kidnapping, 376, rape, 378, theft. They are all called as warrant cases. And another word, Section 2W, summons case, means those criminal cases which attract less than 2 years of imprisonment. Ordinary cases, simple cases, criminal cases, for example, 318, concealment of birth by secret disposal of dead body. Some girls will become pregnant and their family wants to protect her. So they will dispose that child and, or they may give birth to the child and the child's body may be disposed of. And the maximum is 2 years of punishment. It is the summons case. Okay? 323, causing voluntarily hurt, punishment, 1,000 rupees or 1 year of imprisonment. Or 341, punishment for wrongful restraint, 1 month of imprisonment, 500 rupees. So these are some of the examples for summons cases. Okay, so today we have learned 6 words under CRPC. First is bailable, non-bailable, cognizable, non-cognizable, warrant cases, and summons cases. Okay, so this much is enough for today. It's 9 o'clock now, right? So if you have, you can ask me questions in these 6 points. They will ask you for short notes. All these 6 points are very, very important. You have to master these sections. Yeah, please ask if you have any doubts.
Sir, in starting, you said that CRPC, when we talk about CRPC, we have to relate it with IPC more or less. So, sir, what my question is, like you said, CRPC deals with crimes and punishment.
Mhm.
So, IPC also talks about crimes and punishment. Then they also talks about like for what crime, what is the punishment, and like fine or both. So sir, why IPC is known as substantive law but CRPC is known as procedural law?
I'm just giving you only section 2. है ना?
Okay.
So this is only classifying IPC. Okay, we are just taking the first step now. The procedure have not commenced. I'm giving you only the small simple words. These sections will just try to summarize the IPC. If IPC is not there, CRPC is of no use. IPC speaks about crimes and punishment. CRPC speaks about the procedure. How to fix, how to find him guilty, how to prove his innocence. That we have to understand. Okay?
Okay, sir.
Yeah. Enough for today. Now, so today Mr. Hitesh has made some change. So Monday and Friday, okay, we will sit and we will discuss, right?
Yes,
Yeah.
sir.
Enough for today. Good night, everybody. Take care.
Thank you, sir.
Good night. Good night.